Case on this morning's docket. Case number 106661, Jeremy Wiles v. American Family Life Assurance Company, Aflac.
Ready to go.
I wanted to make it quieter for you, counsel.
I'm sorry?
I wanted to make it quieter for you. So whenever you're ready, counsel, we're ready.
We ready to go?
We are.
All right, thank you. Chief, I would like to reserve 3 minutes for rebuttal.
3 minutes is granted.
Yes. My name is Don Vasses. I'm an attorney in Johnson County, and I appear here today representing Jeremy Wiles, who is the plaintiff designated here as appellee, but because there was a reversal of our judgment in the court below, I'm arguing first. I'm asking this court to reverse the decision of the Court of Appeals and reinstate the decision of the trial court, which made basically 2 findings that are important for us today. One, that Aflac, in this case the insurance company, did not prove that the loss sustained by Mr. Wiles was as a result of intoxication. That second, that the defendant failed to defendant limited its investigation to solely to intoxication, did not conduct a good faith investigation. Those are the 2 basic findings made by the trial court on contested issues where there was live and deposition testimony introduced.
Now, with regard to your first issue, that they didn't prove the causation, are you arguing the causation, or that they didn't prove intoxication, or both?
I think it could be said this policy that we're talking about says that it's the defendant has an exclusion, and the exclusion says that we do not owe you any money if the loss was in consequence of intoxication. So it had to prove, its obligation was to prove that the cause of the loss was as a result of intoxication. So they failed to prove both, in my opinion. March 20, 2009 was the date of this incident. Jeremy was at a friend's house watching the NCAA tournaments and admitted that he had some alcohol. It was vodka mixed with orange juice. He did not know the quantity. That has remained consistent from whenever he talked to anybody. He then left his friend's house, and he was driving his car, going around a road. He had his cell phone on the console between the seats, the front seats, and the cell phone, as he went around the curb, cell phone started sliding. He reached for the cell phone, and in doing so, inadvertently steered the car into the ditch. After that, his life changed completely. Jeremy is paralyzed today as a result of that accident. The first responders were called. The sheriff's office showed up with a deputy, EMT, Life Flight, and the Life Flight transported Jeremy to KU Medical Center. There at the scene, the Deputy Sandberg from the Leavenworth County Sheriff's Office was investigating this matter. Subsequently, I'd say maybe, we don't know how long, but sometime after his investigation, he heard from one of the EMTs who said that Jeremy had told him, the EMT, that he had had something to drink that night. The deputy sheriff who was called as a witness testified that the only evidence that he had that Jeremy Wiles had anything at all to drink was this hearsay statement made after the investigation by the EMT. Of course, it was a true statement. There's no question about that, because Jeremy did have something to drink. But the question of how much and how it had affected him was apparently not evident to the deputy sheriff. There was no testimony from the sheriff.
Counselor, you're telling us that the insurance company's obligation of good faith requires that they not only ascertain the true facts, but they must ascertain whether there are witnesses that can testify in court, or that the statements are admissible in court? And if so, what basis in the law? You've admitted that the true fact was that your client had been drinking.
Had something to drink, yes.
Yeah, had something to drink, and the true fact is that the police report says that the officer had an opinion or stated that the drinking contributed to the accident.
All right.
And those are true facts.
There's
Whether
no
they're
question
admissible in court or not,
Right.
those are true facts. Would
There's
you
no
agree?
question. He wrote, the deputy sheriff wrote in the report that alcohol contributed.
And
Now,
it's
but the question you're,
and it's a true fact that there was a blood alcohol test that said his content was .25.
I agree that there's a report that says .250. The only question is, what effect did this alcohol have on Jeremy? Because it's important to note that the officer indicated the only thing he had was this hearsay statement from the EMT. There's no slurred speech, there's no watery eyes, there's no inability to follow instructions. The badges that these officers look for in trying to determine whether someone is impaired under the influence of alcohol are absent. They're totally absent. He has no evidence that any of that existed at the time. It's important also to note that no EMT was called to say that Jeremy's eyes were bloodshot or watery, that his speech was slurred, that he was unable to follow directions, any of those things that you look for. So then he is transported to KU, and as is done when the trauma unit is activated, they have a trauma flow sheet that they go through, and you look at the trauma flow sheet, and they perform a test there. It's called the Glasgow Coma Scale. 15 is the best you can get if your condition is normal. Jeremy's was 15, the best you can get. There was no evidence at all that he was impaired while he was in that emergency room, which was contemporaneous with, I assume, when the blood was drawn. There is a report in Jeremy's chart that his blood alcohol, it says his blood alcohol is .250. That's 3 times the normal limit. If you have a person who is got a blood alcohol of .250, he should be comatose. He ought to be, he's getting close to alcohol poisoning at that time.
And your point is that that should have prompted more investigation? Is that your point?
Yes. But what happened, what we have in this situation is you're talking about the blood alcohol report, and that's important. I think we ought to have a good understanding of what was done with respect to the drawing of the blood and the testing and the reporting. We have a case called Devine versus Groshong, and it says if you want to lay a foundation for a blood test, first you've got to prove that, number one, the blood was taken under appropriate conditions to guard against contamination. Two, the sample is properly marked and conveyed to the laboratory. And then three, chemical testing is properly conducted by competent personnel. In its opinion, the Court of Appeals stated that there was no witness who was able to identify point number one or point number two. There just wasn't. And I'll explain to you how that developed in the testimony. The first witness—
Mr. Vasquez, if we can maybe summarize a little bit to speed it up. The bottom line is that there was ample testimony about the two procedures used for blood draws.
I'm sorry, what was that again?
There was ample testimony about the two different procedures used for blood draws, correct? Right. And you're saying there was plenty of evidence about what should have been done, what was intended to be done in these situations, but no evidence of what was actually done.
That is absolutely correct. There is no evidence that the three points to be made under Groshong, that was absent. First witness called by AFLAC was a phlebotomist who had been assigned a duty in the lab, and her duty is essentially to pick up something and put it on pick up a tube and put it in a line, and then it goes through a computer. At that time, as I recall, AFLAC wanted to introduce the lab report through this phlebotomist, and she was not qualified to interpret the report. She was used to draw blood. That's her training. So I objected. The court then asked the question, do you have the person here who actually drew the blood? And the answer was, AFLAC attorney responded, yes. She's our next witness. He said, okay, I'll take this matter under advisement, or I'll take this matter under advisement for now and let you call your next witness.
But to cut through this, as I understand it, nobody actually testified, yes, I drew the blood. Is that right?
Nobody ever testified below about it. As a matter of fact,
the best that can be said is these are our procedures. We follow our procedures, but nobody could say I did it on this occasion.
These are our procedures, and trust us, we would have followed them. But there's nobody in there to testify to actually qualify this test under any standard that I know. I mean, I've done a few civil cases, and quite frankly, this was the least evidence. This report didn't deserve to come into evidence, didn't meet our standards.
Assuming that we agree with you on that point, I want to move you, before you're out of time, I want to move you to the second point, which actually, the first point, it deals with $6,000 claim,
Right.
and the second point deals with $61,000 in attorney fees.
Right.
And so I want to move you to that second point, and exactly what does the insurance company have to do to avoid a bad faith denial when they have true facts or what appear to be true facts with regard to consumption, and admission of consumption, police report indicating contributed to, it didn't say in consequence of, like the policy says, but contributed to, and a lab report do they have to then resolve all factual disputes in favor of the insured, or can they rely on those facts?
Well, you know, they ought to conduct a good faith investigation. That's all they have to do.
Well,
in
that's
this
what I'm
case,
asking you. What would have been the good faith investigation under the facts of this case?
Well, it would have been to call Jeremy. You know, they're going to deny this kid's benefits. It seems to me you would at least contact Jeremy, or contact Sasha, his wife, or contact Detective Abramowitz, who put a report in the Leavenworth Police Department record that, in fact, Jeremy told him that the cause of the accident was the cell phone sliding off his console and him turning the wheel into the ditch. They should have done that. They didn't.
And if they had of, and it had the information that he claimed, the insured claimed that it was a distraction, but they had evidence of intoxication, that's what I'm asking you. Do they then have to resolve it and take his statement as the true
Well,
facts?
I think they would have, because they would have found out that they had a lab test that their own witness had indicated was seriously compromised. Nurse Bush, for example, testified pretty
Okay,
directly.
so let's go back and relate that back to where we were headed on the good faith investigation.
Okay?
How would they have determined that the blood test was suspect?
Well, they would have, first of all, they would have determined, I guess, talked to Nurse Bush, because she was supposed to be the person who knew, or they talked to somebody. They'd find out that, in fact,
How would they have known Nurse Bush? Her initials were not on
I guess they'd try to find out. I mean, we were 2 years after the event at trial. And it would seem to me that some investigation
Yeah,
could have
okay,
been done
so-
in that 2 years that would have disclosed who the person was, what the draw was, and what kind of preparation was
To
made.
take you back, you're saying that good faith investigation by an insurance company under these facts would have included finding out who drew the blood and then interviewing that person.
Yeah, they knew from day one that they were going to defend this case on the basis of two documents. One was the blood test. Second one was this police report, and the police report's inadmissible. I mean, if they just would have called their counsel, they would have said, well, you can't. There's no introduction there. We can't use it. And then you go, well, okay, we got to prove, we got to lay a foundation for this test. 2 years goes by, and it isn't until the day of trial they call Mrs. Bush and they say, "Are you the person who drew the blood?" She said, "No." Total surprise to me. I figured that she'd say yes, but no, they said no. She said that is it possible to determine who actually took the blood, whether it was you or somebody else? According to the documents I have present, I don't think so at this time. Question, have you had an opportunity to look through Mr. Wiles' chart from the emergency room? I did look at it the other day with my supervisor. And were you able to determine whether it was you or somebody else who drew the blood? Answer, no. Now, that was from their own witness. I mean, I figured they said she was going to testify that she was the one, and I fully expected her to say something. Turns out that she wasn't. But then she said, she just offered this up on her direct examination, that in fact, for legal purposes, we use betadine to prepare the site. For trauma cases, we use alcohol. We use ChloraPrep, and I think the ChloraPrep contains alcohol. Now, would the
Counsel,
application of an alcohol prep, can that contaminate a specimen? Answer, I suppose it could, because we don't use it in legal specimens. I suppose there's a possibility, I don't know how much or for certain, she's kind of, she's answering that question sort of after having said that they use a preparation that has alcohol in it. And maybe that explains the 2.250. I don't know. I don't know what explains it because nobody was there to testify about how it was obtained, how it was marked, how it had Jeremy's name on it. None of that was brought, and so we have a situation where the court, I think, just found it was unreliable, and that the only explanation for this that he could see was that the accident happened as a result of the cell phone sliding off the console and Jeremy reaching for it. It was an inadvertent accident. It was tragic. It was inadvertent. Doesn't make any difference. That's what caused the accident.
Counsel, we understand your position. We'll see you on rebuttal. Thank you.
I'm sorry?
We understand your position. We'll see you on rebuttal.
Yes.
All right, thank you.
May it please the court, I am Tom Carlock from Atlanta, and I certainly do appreciate y'all letting me talk to you. I want to bring forward a couple of points on behalf of Aflac. And I want to address the facts of the accident a little bit, as well as the Aflac policy that in fact has a provision about due to a person being intoxicated, and our judge substituted in consequence of, which is fine with us. Your statute provides that at .08, there's a prima facie case, the individual.
That's for driving under the influence, sir.
Right.
Why is that applicable to a contractual agreement?
Because that shows that he was intoxicated, and Devine says that that statute applies to our circumstances.
Actually, our statute, sir, says in Kansas, it has a .08 per se violation, but it also says without the test, you have to prove that the person is under the influence to the extent that he or she is incapable of safely operating the vehicle.
Sure, and that's the way it is at home, too. I mean, I think that's fairly uniform. In this particular case, the undisputed evidence is that Aflac had in his possession, as was pointed out, the police report and the accident report. As I stand here today, Mr. Wiles has never said, he never testified, he never said anything to Aflac and said, I was not intoxicated. There is no way that report could be correct. Absent from this, in the undisputed evidence is, on this particular Friday night, which I believe was March Madness, and I believe I checked and Kansas was playing North Dakota State, he went with a couple of his buddies, and he drank an unknown amount of screwdrivers, is what I think they call them, orange juice and vodka for 2 hours. He was very close to his home and very close to his friend's house, I think. If you look at the accident report, you can see that he was driving along this road. It was a clear night. There was no other reason for the accident. It wasn't a bad curve to the left. He straightened out the curve, and then you look, well, why did this accident happen? Well, 4 days after this accident happened, when he was talking with another officer, he told this officer, I was reaching for my cell phone, and that's what caused the accident. Now, first and foremost, let's talk about the cell phone. He testified that that's what happened at the trial of the case. And he testified that after the accident, and he was rendered a quadriplegic in this accident, he could see the cell phone on the floor, but was unable to pick it up because of his paralysis or his fingers or whatever. But yet, the cell phone after the accident was in his pocket. And that is unrefuted, and this is something that Mr. Wiles agreed to. So the question becomes, how did it get in his pocket if it was on the seat, and is that reliable testimony? I would also.
Can I interrupt at this
Sure.
point to ask you to remind us what our standard of review is with this? On the first issue, on the first point of the trial court's determination that it was not the cause, intoxication was not the cause of the accident.
To me, you can review this on a de novo basis. However, I understand that our Court of Appeals used an abuse of discretion. But
And
to
so
say.
it sounds to me like you may be asking us to reweigh evidence.
No, I'm saying, asking you to affirm the Court of Appeals. I understand we're going back to the trial court on the first issue of causation. What I am talking about now is the issues surrounding the denial and whether or not that was appropriate in good
Okay.
faith.
So
But
on the first, so you're skipping to this second issue?
yeah, I really should have been clearer on that. I do understand that we're gonna go back to the trial court on the $6,000 issue.
So you're basically willing to concede that $6,000?
Well, I really
issue?
hate to, but I don't think I have a very credible, I mean, I guess somebody can evaluate facts in a way that doesn't make sense to me.
So you just want us to focus on whether or not Aflac acted in good faith
Yeah.
with its investigation?
I think that's a fair statement. I would love to get up and say, you know, I think you ought to direct a verdict for us and go back, but I'm not so sure that's what you folks do, so. But on this issue of the investigation,
I just want to get clear with Justice Luker's question about our standard of review, now that I know you're focused on the second issue and not the
I
first
really would
issue.
like to focus on the first, but I understand.
But let's talk about the good faith denial. What's our standard of review when an insurer denies an insurance claim and it's challenged on appeal like this? We have the district court that's found bad faith. What's our standard of review on that determination?
The Court of Appeals used an abuse of discretion standard as I read their decision. Admittedly, I'm a little bit weak on that here in Kansas. To me, it would be okay to use a de novo standard, but I think you arrive at the same conclusion.
Does
I'm not
our-
so sure I answered your question.
Do you have any case law to cite us to that would say de novo versus abuse of discretion? We
we'll
have a
see.
lot of case law on insurance bad faith, and it seems like it's pretty consistent using abuse of discretion.
Yes, and I believe that's what the Court of
Okay.
Appeals did, so I'm not really fussing about that either.
Okay,
I-
okay.
I don't think. But Aflac received this information. The question is, do we need to do anything else? I would suggest to you, if you have this accident report that shows alcohol contributed, that shows there is no other reasonable basis for this accident happening, and you have a toxicology report that says you're .25, which is 3 times the legal limit. I don't know, and there wasn't any evidence except your common sense is, you're supposed to be comatose when you're .25. If you're 30 years old and drinking an untold amount of vodka with your buddies for 2 hours, I would suggest to you he did not even step forward and say, well, I only had the proverbial 1 or 2. Perhaps in his experience he keeps refilling over a period of time. But if you're out there saying I had an untold amount of alcohol and had this type of accident with this type of report and this type of toxicology report, the question is, what else should Aflac do? What else could they do? Well, first of all, they can't make anybody talk to them at the hospital. Second of all, and I think this was in the Court of Appeals decision, medical professionals are not really called upon to remember each and everything they did. There was evidence in this case that the chart followed the patient. He came in a quadriplegic. He did not come in under arrest. The testimony was we were more interested in taking care of a critically ill patient than touching some procedural basis of initialing charts and things. So Nurse Bickert, I believe that's the correct pronunciation, testified, and we had 4 people there to testify about the policies and procedures. We had the head nurse testify that this Nurse Bickert was the one who was there. We had her testifying I was there and this was done. but I just can't tell you I was the one who actually drew the blood. And that is the missing ingredient the plaintiffs are trying to tack on to the Devine decision. However, the Davis decision, as pointed out in '09, involved exactly that, and the court said you don't have to have the person who actually drew it. In other words, a period of time later, you drew it. My question is, assume that's the case, how would Aflac know that? How would Aflac know that Nurse Becker did not initial the chart?
But isn't it I guess I've got to interrupt here because I don't think anybody's talking about what we want to hear. You know, we're trying to focus on what was the good faith obligation of Aflac. And it does seem to me that the district court's decision is about as bare bones as you can get on this particular point. And so regardless of whether the blood sample was marked or not marked, how would that impact Aflac's good faith duty in deciding to deny the claim? It seems like that it doesn't need to know that to know whether there's a genuine issue in good faith about whether it should pay or not. So how does this relate?
Is the court question this? If you have the accident report and the toxicology report, does that mean that you have to go further in your investigation? Is that what the court's asking?
Yes, and the finding of the district court is that you have these reports and that's not enough. It says, that Aflac did not have sufficient evidence to deny the claim without investigating. So don't we have to focus on, you have the toxicology report, you have the accident report, does this key a duty on Aflac to do anything more before it denies the claim?
My answer would be, given this document's no. However, if those documents had something in it about something else, perhaps. That would be very fact-driven, I would think, about good faith or not. But if you look at...
What about the contrary evidence? The trauma flow sheet where indicated that they did the eye test, they did the cognitive test. All those would contraindicate intoxication to the point of being incapable of safely operating.
While there is no medical evidence on that particular point, I would suggest to the court that doesn't address really the intoxication issues. Those Glasgow Coma Scales are the tests they give people in paralysis case to try to figure out what's going on. You understand that when he came in, the blood was not drawn for DUI reasons. The blood was drawn to take care of him medically, and we happen to have those particular results. So that's not something they were looking for. If they were going to go down that road, they should have produced some medical evidence. But I would suggest to you that doesn't really address the question that Mr. Wiles' attorney is raising.
Your position.
Excuse me,
No,
can I follow up?
Sure.
So you're saying the Glasgow Coma test doesn't contradict the blood alcohol content results?
I'm pretty familiar with those. I've got involved in some cases involving them. I would say they're a cousin too, but the answer is I don't think that would lead you down another path. Even if Aflac got that, you'd have to be a pretty...
But would it lead Aflac into a question that it should resolve by investigation? That's where we are.
I can't imagine that being true, but knowing what I know about Glasgow Coma Scales and knowing what I know about severely injured people and what they're looking for, I would say no.
Regardless of what you may know in your information, is there anything in the record in terms of what was presented to the trial court that would put that issue in play? I mean, did they present evidence on that? Did you present evidence on that?
I think they brought up that point, and it was really argument of counsel based upon the record, but there was no testimony as to what that means. And from a doctor's point of view, that would equate to A or B. And what I'm telling you is just what I particularly think. But I don't think if somebody from Aflac had those medical records and looked at it, would be sophisticated enough to say, aha, this is an indication he wasn't drunk. You understand that when we sent the denial letter to him, we were notified of the accident and the claim about a week later on a Friday. And the claim was denied about a week later. I'm not sure. Nobody ever came back and said, hey, I wasn't drunk, look at this, or talk to my buddies or whatever.
Once you had evidence that he was drinking the vodka and orange juice, and the BAC that came back, .25, was that sufficient for a good faith basis to deny the
Sure.
claim? That's it. I mean, that's
Sure.
basically your argument.
Sure,
That's
sure.
it. That's
Now-
sufficient
now-
right there, and that's good faith.
All you gotta do is stick in another little fact, and maybe you'd go down a little bit more of a road, but sure. I mean,
That's enough.
And-
we're sitting there evaluating things, you get this information, and it points to one thing.
Okay.
And the court's conclusion is that it was not sufficient to be in good faith.
The trial
Sure,
court.
The trial court. So I come back to a question we posed a few minutes ago, and I wasn't sure what exactly your answer was.
Well, probably because I didn't know.
Oh, that's all right. We review the district court's determination that your efforts were insufficient to constitute good faith under what kind of a standard?
I knew you were gonna ask me that question again. I think you can review it on a de novo basis, but I do understand the wealth of authority is abuse of discretion, and that's what the Court of Appeals did. But I believe you get to the same destination going down either.
And for us to find that there was an abuse of discretion, we would have to determine what?
You would have to
That-
determine that Aflac had a good faith investigation of this matter.
Well, I think we're perhaps talking past each other. There are three different ways that this court in the last few years has said that's an abuse of discretion. For example, no reasonable person could have agreed with the trial court's determination. Is that the part of abuse of discretion you're relying on, or are you relying on one of the other tests that we use within that general test?
Candidly to the court, I'm not familiar enough with exactly what you asked. And I've learned long enough, I got enough gray hair when I don't know, I'm not gonna venture. I would ask the court to give us a few days to brief that. But I'm struggling with that question.
All right, fair enough, thank you.
And,
Well, the other two are that the decision wasn't based on correct law, it was legally infirm, or that it was based on a factual determination that wasn't supported by substantial competent evidence.
Right. Well, to me, what the trial court did was impose a burden beyond the holding in Divine and to say we had to say Jane Doe drew the blood, which is even contrary to Davis. So if that's the standard, clearly the Court of Appeals did the right thing.
All right, counsel, I see you're out of time. Would you like 30 seconds to wrap up, or do you feel you've made your points?
I feel like I did to the best of my ability. And again, I really appreciate you folks having me here. Thank you.
All right, do it.
Could I
Sure.
nail something down
Uh-oh,
to be
uh-oh.
absolutely certain? I understood you to say that that part of the trial court's ruling, that your client owes $6,000 on this claim, is, you're not challenging that at this point. Is
Well,
that
let me
what
be
you're
candid
saying?
about that. When I saw that, I really believed that we should ask you guys to reverse the Court of Appeals on that and grant us a judgment that they're not owed $6,000. But on advice of very competent counsel here, no, we're not. So we're willing to go back to the trial court and deal with this $6,000 issue. Understand, Aflac, believe it or not, is a caring company. This gentleman was severely hurt in a single-car accident, and, you know, we're sorry about that.
Any more questions? Thank you, counsel. You're reserved for 3 minutes for rebuttal.
The standard of review is abuse of discretion, no question about that. You asked counsel what should Aflac have done? Well, they got, here's the documents that they had. They had the claim form. The claim form included a medical report from Dr. Barefoot, who was the surgeon. There was not one mention in the medical report about alcohol or intoxication. That should have at least raised some index of awareness with someone that maybe we ought to call him. We've got another report here that shows alcohol. Was there, wasn't there? I mean, but they didn't. They could have called and talked to Detective Sandberg, who filed the original report. Were any charges filed, a DUI or anything of that nature? The answer is no. Well, why wasn't that done? We've got something here that indicates, and then take on an investigation after that. In terms of what Aflac's duty is, that's already been decided in a case you decided last week. That was the Tomlinson case, and I sent in a letter, a 60B letter. There is a statute in Kansas that says it's an unfair claim settlement practice if any of the following or any rules and regulations are committed flagrantly or in conscious disregard of the provisions. And the one that applies here is D, refusing to pay claims without conducting a reasonable investigation based on all available information. So
Mr.
you
Vassos,
need one sense of, yeah.
at trial.
I'm sorry?
At trial, what evidence did you put on that the toxicology report, the accident report, and the claim form were not enough for the insurer to go ahead and deny the claim? Well, I mean, was there any evidence, or was it argument of counsel?
Well, I mean, if I understand you correctly, each side chose the exhibits they're going to introduce, and we asked for we referred to the claim form. That's all they had. Then the lab report, and then the investigation report.
You didn't put on any evidence
Yes.
of an insurance company consultant or expert who would have said a insurance company looking at this information should have done X, Y, and Z, or should have
No,
done
we
the thing.
didn't have any expert testimony.
So this was
Neither
argument-
neither
this-
side called any experts or identified any experts.
So the trial court's, and I'm struggling because I've got this bare bones order that we're looking at that just says, yeah, they did it. It doesn't even say what they, did or
Well,
didn't do.
I think I was there to listen to the court, and I know that he made two comments. One in the memorandum decision, but then the one at when we had the hearing on attorney's fees. And the court felt compelled to at least point out again that, look, you guys didn't do anything with respect to this issue of, is the sliding cell phone, is that even involved in this case? You have a lot of difficulty finding that their evidence with respect to proving up this lab report. He had a lot of difficulty with saying that this showed anything was reliable. Then he had the evidence that there was none of the badges of intoxication that were evident by any witness. None of the witnesses testified about that. And so he's trying to weigh this evidence, and I think at the time at the attorney's fee hearing, he was just kind of frustrated, like, you didn't do any kind of investigation with respect to the other issue that it was the big elephant in the room. This sliding cell phone was identified as a cause early in the case. They never paid attention to it, didn't investigate it, didn't want to hear about it And even when they did hear about it, they denied it occurred.
Mr. Vazos, the fact that there was a sliding cell phone doesn't negate the proposition that the accident could have occurred as a consequence of intoxication, because intoxication byproduct is inability to react. And so just the fact that there was a sliding cell phone would not resolve the factual question of whether this accident was as a consequence of intoxication, would it?
Well, I think it goes a long way to explaining why the accident happened.
Well,
In
it
the
may
absence.
explain what, something else that may have contributed, but my point is, you still would have a factual question, because we know he was drinking. That's slam dunk.
That's
no
a slam dunk. I agree.
He was
I agree.
drinking, and so you have a factual question as to whether that, any intoxication he may have experienced from that drinking, caused the accident, right?
Well, let's look at it this way. Who has the burden of proof in this case? Aflac. Who has the burden to introduce evidence in support of its exclusion? Aflac. The court made a determination that that it had failed in its obligation to prove that this accident occurred by way of intoxication. Now, there was certainly another alternative explanation when you have the absence of all these badges of intoxication that police officers look for and people in emergency rooms look for. None are present in Jeremy's case. So that made the lab report. I know, I mean, if it's a valid report, that's, you know, we're dead. But that wasn't the situation.
Counsel, we understand your position and you're out of time. Would you like 30 seconds to wrap up?
I would ask this court that the standard that I thought occurred on appeal when you're on appeal and you're considering what you're going to do on appeal with a case is that you're not going to reweigh the evidence and you're going to give great credence to the trial court in making its decisions. And in this case, I think it's just apparent, at least to me, that the Court of Appeals chose to reweigh the evidence and to arrive at a conclusion different than what the trial court did. It may not be the decision that they wanted or would have made if they had been the judges below. But this is the decision that the judge made, who heard the evidence, listened to the witnesses, saw their demeanor, and it seems to me that he's entitled to great weight.
All right,
Thank
thank you, counsel. Court will take this matter under advisement.